Alex Thompson, he may have been the one that wrote the New York Times article. I have to confess, I do not have a New York Times subscription. I can't bring myself to send the New York Times money. And this article is behind a paywall, so I'm kind of counting on secondary sources here. But I believe the article may have been written by this Alex Thompson. He writes, quote, Biden did not individually approve each name for the categorical pardons. Rather than ask Biden to keep signing revised versions, his staff waited and then ran the final version through the Autopen, which they saw as routine. Routine. A little more text here from that article. Let's see. Biden did not individually approve each name for the categorical pardons that applied to large numbers of people, he and aides confirmed. Rather, after extensive discussion of different possible criteria, he signed off on the standards he wanted to be used to determine which convicts would qualify for a reduction in sentence. Even after Biden made that decision, one former aide said the Bureau of Prisons kept providing additional information about specific inmates, resulting in small changes to the list. Rather than ask Mr. Biden to keep signing revised versions, his staff waited and then ran the final version through the Autopen, which they saw as routine. Reporting on this by the Gateway Pundit, Biden Autopen scandal, they say. New York Times confirms Biden did not sign off on all pardons. White House Chief of Staff Zients approved Fauci's pardon. He writes, the Biden Autopen scandal just got worse. The Oversight Project broke the story about the Biden Autopen scandal wide open after they discovered thousands of acts of clemency and executive actions were signed with an Autopen rather than a wet signature by Biden personally. So this is part of the overheated emotional hysteria around this topic. Is something signed by an Autopen invalid if it's signed by an Autopen rather than a wet signature? The answer is, of course, not. Lots of things are signed by Autopen. They're perfectly valid. So the fact that pardons were signed by an Autopen does not make them invalid. Earlier this year, the article continues, the Oversight Project revealed 6 criminals were pardoned by Biden's Autopen on December 30th, while Joe Biden was vacationing and golfing in St. Croix. Well, folks, that's why Autopen exists. Autopen exists for when the president cannot be or is not personally present to sign himself. If the president's in the room and you present him with a document, you obviously would not use an Autopen. You would just have him sign it. So the Autopen is specifically for circumstances in which the president is not physically present to sign, but would sign if he were there. That's why the Autopen was created. That's how it's been used by every president, including Trump, since it was created. So this notion that pardons were signed when Biden was not present, he was in St. Croix, and back at the White House, the Autopen was used, that doesn't make that pardon invalid. I mean, just think about it. We just have to apply some common sense. The New York Times, and then it refers back to the New York Times article. Now, of course, lots of people are jumping on this, including friends of mine. Tim Pool, you see the little coaster right there from the last time I was on Tim's show. Tim has me on from time to time. He writes, holy F, the pardons were fake. The pardons were fake. And he's citing here to the New York Times article. But what's said in the New York Times article does not make them fake. Not make them fake. Kurt Schlichter, another good friend of mine. Hopefully I'll get to see Kurt again this summer on my annual visit out to Southern California. Kurt's, of course, a lawyer and a prolific author. Lots of great works of fiction. You should definitely check out Kurt on Amazon.com. He just released his most recent book, in fact, another work of fiction. Does great work. Kurt writes, I remember how I said the Autopen thing was a big nothing. Yeah, I'm taking that back now because I couldn't conceive of this. And he refers as well to the New York Times article. I have to disagree with both Tim Pool and Kurt Schlichter on this. Now, what is the pardon power? Well, the pardon power is a core and plenary power of the president under our U.S. Constitution, under Article 2, which defines the authorities of the Article 2 executive branch president of the United States. And it says the president shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment, which doesn't apply here. So note what it doesn't say. It doesn't say that these pardons have to be personally signed by the president. It doesn't say you can't use an Autopen. It doesn't say the offenses need to be specified. It doesn't say the individuals need to be specified. It doesn't even say that the pardon has to be written. This is a core and plenary power of the president to issue a pardon for offenses against the United States. The president could simply stand up and say, I hereby assert my authority under Article 2 of the U.S. Constitution to pardon Attorney Andrew Branca for all offenses against the United States. And what if he doesn't document that in writing for, say, a month? And he doesn't sign it for yet another month? What's the effective date of that pardon? Is it when he signs it 2 months after the oral statement? Is it when it's put in written form a month after the oral statement? No, the pardon is effective the moment the president asserts that authority to issue the pardon. Him making the verbal statement alone is sufficient to assert the pardon. It need not be signed. It need not be written. Now, of course, it's helpful when things are written down and signed because that provides clear documentation that something in fact occurred. That's why it's the normal practice. And these, by the way, these Biden Autopen pardons may have been illegal. They may be invalid, but they have the appearance of being valid. They are written down. They are signed. So they have the indicia of being an exercise of the will of the Article 2 executive branch president at the time. Now, what about this notion that names were not specified? That Biden sometimes specified individuals, but sometimes specified classes of people. Does that mean a pardon's invalid if it doesn't name specific names? And the answer is, well, apparently not. Because this has been done before, and the pardons have never been contested, issuing pardons on a class basis. Even a class basis where the persons within the class, the unnamed persons within the class, have never personally even been convicted of a crime or prosecuted for a crime or charged with the specified crime. They have the mere potential to be charged with the crime because they fall within a class of people defined by the Constitution. Jimmy Carter did this. By the way, President Trump did this. President Trump himself pardoned a class of people without naming them individually. And this applies, of course, to the January 6th pardons. Let's take a look at it. Granting pardons and commutations for certain sentences for offenses relating to the events of January 6th. So he commutes several sentences, and these people he names individually. Fair enough. Then he grants a full, complete, and unconditional pardon to all other individuals convicted of offenses related to events that occurred at or near the United States Capitol on January 6th. By the way, in theory, this could apply to someone unrelated to the January 6th protest who committed a mugging at or near the U.S. Capitol on January 6th. This pardon would apply to that person too. But putting that aside, I'll only note here that this does not name these people individually. It simply says to all other individuals. It's a class of people. So a class of people is, even by Trump's standards, permissible for the issuance of a pardon. Now, the nice thing about Trump's use of a class is the class, while not defined individually, is definable, because at least Trump requires that the class consist of people who were convicted of offenses. Well, there'll be a record of convictions. So if someone wanted to, we could go look and see who were all the people convicted in these terms that fall within this class. So it's a knowable list of people. It's kind of an implicit message that if prosecutors were attempt to convict others, well, then they would also fall within the class, and they would also be the beneficiaries of this pardon. But the class pardon has been used before without requiring conviction or even being charged. This happened when Jimmy Carter issued a class pardon of people who avoided the Vietnam War draft. So here in January 21st, 1977, Jimmy Carter, President of the United States, grants a grants a full and complete and unconditional pardon to all persons who may have committed any offense between these two dates, a 10-year period roughly, in violation of the Selective Service Act. Who may have committed an offense. It's not required that they committed an offense or were charged with the commission of offense or prosecuted for the commission of an offense or convicted. This is really an unknowable class of people. We can never have a complete list of these individuals. He merely defined a broad class of individuals, didn't name them individually, and it's in sufficiently broad terms that it would be impossible to document who they all are. So all persons who may have committed any offense, and there's never been any credible argument that this pardon has been invalid. It was never challenged. And it's not even required here, at least he says, who may have committed any offense of the Selective Service Act. But does a pardon have to specify, even in general, the nature of an offense against the United States in order to be a valid pardon? The Constitution doesn't say this, right? The Constitution says the president shall have the power to grant pardons for offenses against the United States, but it doesn't say they have to be specified. It doesn't say for any specific offenses against the United States. And in fact, in the same decade as Jimmy Carter, just a few years earlier, we had President Ford. President Ford, of course, assumed the presidency. He was the vice president of President Richard Nixon. Ford assumed the presidency when Nixon resigned in the aftermath of Watergate. And Ford issued a pardon to Nixon to prevent a witch hunt and the prosecution of Nixon. He did that on September 8th, 1974. Let's see. Pursuant to the pardon power conferred upon me by Article 2, Section 2 of the Constitution. Sorry, I forgot to pull this up. This is it here. Proclamation 4311, granting pardon to Richard Nixon, September 8th, 1974. Now, therefore, I, Gerald Ford, President of the United States, pursuant to the pardon power conferred upon me by Article 2, Section 2 of the Constitution, have granted, and by these presents do grant, a full, free, and absolute pardon unto Richard Nixon for all offenses against the United States, which he, Richard Nixon, has committed or may have committed or taken part in during the period from January 69 to August 74, when he resigned. There's no specified offense here. It's not the Selective Service Act. It's nothing in particular. It's any and all offenses against the United States which he might have committed. So pardons are valid even when a specific criminal charge is not named. A mere charge. It certainly doesn't require a conviction or even a prosecution or even a charging with a particular crime or even a particular crime stated in the pardon document. So if any or all of that is absent in any of these Biden pardons, it's irrelevant. It doesn't make the pardon invalid. As I already mentioned, the use of the Autopen does not make these pardons invalid. The Autopen is permissible. There's nothing in law that says the Autopen is not allowed. There's nothing in law that says the Autopen can only be used for superficial documents, which tends to be how Trump uses it. Trump uses the Autopen too, but he tends to use it not for important documentation, but for things like responses to letters sent to the White House from fans. And I think that's the most appropriate use of the Autopen. But there's nothing that restricts the Autopen from being used for important documents. It's been used by many presidents for many important documents over the years since it was invented. And those have never been challenged as being invalid simply because an Autopen was used. So what is decisive about all this? What would be the one factor that could invalidate all these pardons? And again, I wish many of these people, especially people like Fauci, had not been pardoned. I think Fauci is the Dr. Mengele of modern day America. I think his policies, his lies led to the deaths and physiological maiming of millions of people. There's no punishment in my mind that would be too severe for Anthony Fauci. But he was apparently granted a pardon by the President of the United States for offenses against the United States. Now, I will note that presidential pardon doesn't protect Fauci from civil lawsuit. A presidential pardon does not protect anybody from a civil lawsuit. It protects people from federal prosecution. So anybody harmed by Fauci, in theory, would have grounds to sue him personally. The states can sue him personally. A presidential pardon does not inhibit state action. Folks, as always, if you have I see good questions and comments here in the chat, but they do need to be $5 super chats for me to address them during the live stream. So if you asked a good question you'd like me to address, but you did it as not a super chat, it's got to be a $5 minimum super chat. So I would love to see Anthony Fauci prosecuted to the ends of the earth, but he appears to have been issued a presidential pardon, which protects him from federal prosecution. So, and of course, there's many other people that equally despicable. I mean, Biden was, after all, basically running just a crime family. So all his family members he pardoned, his son he pardoned, all these people. I'd love to see them all prosecuted. But our Constitution gives the president the authority to pardon people. And Joe Biden was supposedly elected president. We pretended he was. I mean, I think we all know now that election was stolen. But nevertheless, we allowed him to assume the presidency and assume the powers, the core and plenary powers of the presidency, which includes the constitutional power to pardon. So if the Article 2 executive president simply exercises his core and plenary authority, exercises his will as the Article 2 president, that's it, folks. That's it. It's over. That's a valid pardon. It's simply an exercise of his will. Now, in order for everyone else to be aware that this exercise of will occurred, it can't just occur in his mind. There has to be some external communication to the world, or we would not know that his will had been exercised. But that communication can be de minimis. It can simply be a statement. If Biden had stood up at a lectern and simply said, I hereby assert my authority under Article 2, Section 2 of the Constitution to pardon Anthony Fauci, that is a perfectly valid pardon. It need not be written down. It need not specify a crime. It need not be signed personally. It need not be signed at all. Now, again, the document and the signing is helpful because, well, it documents the assertion of the pardon power as a act of will by the president. But if it was an act of will by the president, the act of will alone is enough. So what could make these pardons invalid? What could make them invalid would be if there was evidence that any one of these pardons were not the result of an act of will of the president. So if Joe Biden were to stand up and say, I never approved that pardon arguably would be invalid. Now, of course, whoever got that pardon might say, wait a minute. No, there's evidence that he did approve it. For example, he signed it personally. He can't on camera. That's one of the nice things about when Trump signs these executive orders and pardons and other important documents, by the way. I love the fact that he sits at the Resolute desk and they're all stacked up, and it's an aide pops it open and explains to the president what the document is, what its implications are, hands it to the president, all done on camera with press in the room, in public, in real time. And President Trump takes the document after its import has been explained. He'll typically say a few words about it, grabs his pen, he signs it there in person, right on camera. That is the ultimate documentation of the assertion of President Trump of his political will as the Article 2 executive branch president of the United States. Fantastic. Frankly, that's how it should always be done. But none of that's required by the Constitution. So if we don't have any of that, if we don't have any of the common indicia of an assertion of will, and President Biden were to stand up and say, listen, I know that someone's shown up with this document that purports to have my signature on it, pardoning Anthony Fauci. I never signed that. I never approved of a pardon. I did not wish Anthony Fauci to have a pardon. Well, that would be evidence that Anthony Fauci's pardon is invalid. Or perhaps it could be argued in a court of law, because it would end up in a court of law, of course. If there was evidence that President Biden was so mentally incompetent that it was impossible for him to assert his will. For example, if someone is not of sound mind and body, they might write a will, they might sign a will, but if they're mentally incompetent, that will is invalid. If it could be documented that President Biden at the time that these assertions of the pardon power were supposed to have been made, that he was mentally incompetent to assert his will, arguably those pardons would be invalid. Here's the problem, folks. It's much like this Epstein list nonsense. Where's the evidence? Where is it supposed to come to? We can all have feelings about it. I certainly feel that President Biden was incompetent, that he was a puppet being manipulated by his staff, by evil anti-American forces. I believe that. But I'm making a lot of inferences. I don't have the evidence to take that into court and make that argument and sustain my burden of proof, which is what you'd need to do here. Now, belief is enough for political purposes. Belief leads us to pull one lever over another in the voting booth, and that's perfectly appropriate. I mean, God forbid we ever put the Democrats back in power again, as if we don't already know how they'll conduct themselves. So your beliefs, your feelings about issues are more than sufficient to make a political decision in the voting booth, but they're not sufficient in a court of law. And to overturn any of these pardons, that would have to occur in a court of law.
Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.